on the cloud. There we go. So welcome once again, everyone. The introduction this time will be shorter. This is part 2 of LAMDA's 7-part series on practicing before the Consent and Capacity Board. Today's session is about challenging findings of treatment incapacity before the Consent and Capacity Board. We're very fortunate to have 2 LAMDA members who are leaders in the bar and do a lot of work representing patient applicants in challenging physicians and healthcare practitioners' findings of treatment incapacity, Danielle Chong and Naomi Sayers. And they will take it from here. They've got something great planned for you. There are some materials for registrants. In terms of CPD, we're not sure yet an application will be made, I think, for some professionalism CPD in relation to this session, but if not, you'll certainly be able to claim 1.5 hours of substantive CPD for this session. I'm going to go off camera, and if you have questions, you can put them in the chat, or you can raise your hand, or you can probably interrupt and ask those questions as well. You're going to have a great session. Thank you so much, Danielle and Naomi, for being here. And off you go.
Thank you. So I know that session 1 dealt with how you handle a file when it comes in. So you've already had those introductory remarks from Anita. So I'm going to jump right in. Okay. So what do you do when you have a hearing with dealing with incapacity? So once you get the file, you review the medical records. And what I like to do is I go to the legal document section right away and I pull out the Form 33. And that's where you see where the incapacity relates to. And usually in these cases, it relates to treatment. So I'm going to focus most of my remarks on treatment. Later on, we'll also deal with property and also personal information, which is, rarely the case. So I pull out the Form A, I pull out the Form 33. I record the dates and the name of the physician. It's usually the most responsible psychiatrist, the attending psychiatrist, but not always. And after that, what I do is I go directly to the medical progress notes section. And what I proceed to do is I flag all the sections that deal with capacity assessment. So you've got to go through all of the notes. And of course, in a lot of these cases, the patient has also been involuntarily detained. So I will also, of course, make a note of those legal forms, those dates. I always make a note of, when the Form 30 was filed. I make a note of the expiry dates. Also, I always ask for discharge summaries. I know that in the last session we were talking about, I think Shira asked, how far back do you go? And I think there was some discussion about, well, sometimes you go back 6 months and sometimes you go back 1 year. Well, what I like to do actually is I don't ask for the progress notes, like the daily progress notes, the interdisciplinary notes going way far back, but I do like to ask for discharge summaries, sometimes for as back as 2 years, maybe even more. And I ask them to only provide me with the discharge summary so I don't get, burdened with a whole whack of, thousands and thousands of pages. And the reason I like that is because I like to see whether or not my client has actually been found capable on those past admissions, or whether or not my client has always been incapable. And I think that that is historical information that is valuable and that can be used on cross-examination. So going back to the progress notes, though, I note down all the assessments, and there can be more than one assessment. So sometimes what happens is that they will start the assessment and it's not completed. And then sometimes it's started by a resident. Sometimes The attending physician will come in and will do it again, do it over. Sometimes the attending physician will pick up where there have been, blank spots in the assessment and will try to fix them up. All of those assessments, I think, are important. And the other thing to remember is you may request your records maybe, on working backwards on, day 2 or day 3 after you get the phone call on day 1. But I think it's important to get the updated medical notes because you want to see whether or not there's been an updated assessment for capacity, and that's important. It's also very important to talk to your client before you have the hearing, because in your first conversation, you may get a sense that they are incapable, but with medication and whatever trajectory the hospital stay entails, their presentation may change. So I think it's important to get that updated information. I look for all sorts of information regarding the assessment. I like to see where it was done. I look for that. I look for the condition of the client. For example, is it possible that they were sedated at the time that the assessment was conducted? I even make a note of the time of day. I record how long the assessment was. And I also look to see whether or not there was any other collateral information that was collected. So as I was saying before, sometimes an assessment is started and then the physician notes, oh, I need to go and speak to so-and-so, maybe a family member, maybe a friend to get additional information. And then they go and they collect that information and then they come back. I think that that is fertile ground for a cross-examination because you can ask the physician whether or not their assessment is based on the collateral information or whether or not it's based on their observations in hospital. And if you made a note that there was a conversation, you can have a little bit of fun with that. Let me see. Of course, you want to know about the diagnosis and you want to know what the symptoms are. And so you look for that information. It's usually contained in the capacity assessment, but sometimes the psychiatrist won't even go into that much detail. They will just say, fails branch 2, unable to appreciate consequences. So in that case, I would have to look back in the progress notes to see whether or not there's been a historical collection of information that informs that determination of incapacity on that final date. Because, I mean, what will often happen is that you'll actually be at the hearing and then you'll say, well, you just concluded this, that they fail branch 2, but then the physician will try to clean that up by saying, well, I had a conversation and I did an informal assessment on the previous date. So you've got to look for in the record what looks like informal assessments as well. Okay. Of course, for branch 1, what's most important is whether or not they understand the information. So you have to look at what information is actually given to the client. In the assessment, is there a notation that says that the client was informed of their diagnosis? And I think language is very important here. Is it that they were informed of their diagnosis, so schizoaffective disorder, or whether or not they were informed that they have a psychotic episode, or whether or not they had a mental disorder or a mental condition? So as you know from the law, the client is not required to understand the specific diagnosis, just that they have a mental condition. So even the word mental disorder has negative connotations that may cause your client to say, no, I don't have that. So if that language, if you can find that language in the progress notes, you can also focus in on that on your cross-examination. And of course, I'll talk later about speaking to your client, but I think that if you pay attention to the language that the psychiatrist uses in their assessment, it may give you a flavor of the discussion that they had with the client when they made the determination that they were incapable. Because a client who does not like the negative label, schizophrenia, they may say, no, I don't have that, right? And so you could probe your psychiatrist during the cross-examination by using other terminology. The other thing that you should also note is whether or not there are any other communication barriers, such as language. I like to ask whether or not any family members were present during that time, because maybe they weren't in that room, but if they're in the hallway or if they have a family waiting, that may, again, create situational stressors that would affect the outcome of the capacity assessment. And in that vein, I think that it's also noteworthy that a client may change their answers depending on the condition. So did the psychiatrist give the client an opportunity to be reassessed if the first, I guess, probing was that they're incapable? So I like to look to see whether or not there is an opportunity in subsequent visits for the client, for the psychiatrist to revisit the assessment of incapacity, or is it the case that there's just a finding of incapacity and that's the assumption, they're not going to revisit it and they're not going to probe it again. That's also fertile ground for cross-examination. Okay, I want to talk about what I think is the most important thing in dealing with Form A applications. And that is a conversation with a client. Okay, so in a lot of these cases, your client will be incapable, and maybe they do want to testify. As Anita said in session 1, it's really not a good idea for the client to testify if they're incapable. It's really difficult to win a Form A application if they testify and they just say, there's nothing wrong with me, et cetera, et cetera. When the client is clearly unwell, I will do everything that I can not to have them testify. But they need to unburden themselves and they need to explain their side of the story. And that's why I think it's so important to have that conversation with the client. So maybe you won't explore the areas at the initial meeting because it's uncomfortable. You want them to feel that you're not, telling them that they have a mental disorder. So it's got to be later in the relationship. But I do give them the opportunity to talk about it because they will feel that they've had a chance to express themselves. And it's the safest thing to do it in a solicitor-client private conversation. That way they can say anything they want. They feel that they've burdened themselves. They've had a chance to air their thoughts. It's not a good idea to do this at the hearing. Now, I also find it very difficult when you have a client that is borderline. Sometimes they're capable, sometimes they're not. So in these cases, you can kind of detect that you can maybe prepare the client and that they are able to pass the capacity test. I find that you have to be really, really careful because you don't want to be accused of coaching your client. And that has happened to me where my client has said, well, my lawyer said this, and if I say this, then you will find that. And so it sounds like coaching. And so that's dangerous area that you don't want to go into. So you have to be very explicit with your client that you're not coaching them, that you're not telling them what to say, but that you're merely explaining the test for capacity and you're explaining what the doctor is after and how their answers will affect them. So when you have a client who's on the ball, they can kind of get the gist, and sometimes they will say to you, well, I can say that. Do you want me to say that? Then I will be capable. Of course, you can't do that, but you need to explain to the client that, of course, you want them to tell the truth, but it's your job to explain what the capacity test is and what the consequences of passing or failing branch 1 and branch 2 are. So that's a very delicate area, but the client deserves to know what the test for capacity is. And they will often say, my doctor never told me they were assessing capacity. I was never assessed for capacity. They never talked to me about a substitute decision maker. Most of them will deny knowing about the capacity test. So I actually don't know. Like, I don't want to say that the psychiatrists aren't explaining to them what the elements of the test are. But I can tell you that for the most part, my clients tell me that they have no idea what the elements of the tests are. And my conversation with them is the first time they've heard about it. So I think now we're going to jump to branch 2 of the task. Branch 1 is Naomi and I should have explained this before. We've decided to divide it. So I'm going to talk about, I was supposed to talk about the understanding branch. So you want to make sure that they receive the information. That is a diagnosis. The mental condition is how I like to describe it. The symptoms, the manifestation of the symptoms, whether or not it's written material, whether or not it's just oral. And what I like to do also is look for the educational background of my client, because if they do have a university education or they've been employed for a number of years, it's very difficult for the doctor to, I don't want to say difficult, but you know, it's less palatable for the doctor to say that they don't understand the information. I think that this is very rudimentary, elementary, and in most cases, the doctor will say that they pass branch 1, but not branch 2. And with that, I will pass it over to Naomi, who has a more difficult task of talking about branch 2. Thank you, Naomi.
Thank you, Danielle. So I sent out a little PDF that may have been distributed to attendees. I think it's just useful to just highlight some of what has been said in the case law. So on the second branch, as Danielle was saying, it's objective and most oftentimes it's conceded. And then the second part is what we call the subjective part. And this is where all the nitty-gritty, I guess, analysis of the doctor's assessment happens. So the second branch, plainly put, is about assessing the patient's ability to evaluate, not just understand the information, but the patient must have an ability to appreciate. Sorry, let me just get that. Let me reframe that. The patient must have an ability to appreciate the relevant information as it relates to him or her. So that's defined in the legislation, the Healthcare Consent Act, and it's defined in Starson, and then the jurisprudence that flows from that. In Starson, they also highlight what we call the 3 common indicators of capacity. So whether the patient is able to acknowledge the fact that the condition for which treatment is recommended may affect him or her. That's 1. Number 2, whether the person is able to assess the proposed treatment, how the proposed treatment and alternatives, including no treatment, could affect his or her quality of life. And number 3, the person's choice is not substantially based on delusional belief. For example, one extremely subjective, I guess you could say, indicator of a mental illness would be delusion. So the client, this is just an example. Oh, I don't hear things. I'm sent here by God. I have messages to deliver. So that is not a substantial, that the choice to deny medication is substantially based on a delusional belief. Like Danielle was saying, be aware of collateral information. So anytime you see the doctor saying family, friends, school, police, media, mental health workers, that is where I sort of just turn my mind to in sort of the subjective assessment. Like, where is this information coming from? What is the source of the information? And what are they saying about the diagnosis in terms of the patient. The collateral information, we have the benefit of Section 14 of the Evidence Act, and then also the case law that flows from it. I like to rely also heavily on Section 14 of the Evidence Act, especially if there's any instances of double hearsay. So not just hearsay, but also double hearsay. So that may show up in the instance of a mental health worker speaking to a mom and then the doctor relying on the mom. So did the doctor actually talk to the mom? When did the doctor talk to the mom? Did he make any attempts to reach out to the mom? And does the patient even have a relationship with the mom? When was the last time the patient spoke to the mom, right? So those are hallmarks that that I always pay attention to and markers in my case. In terms of the assessing this branch in terms of the health records, I do have an example. I don't know if we're allowed to provide it. I removed any identifying information. If Anita?
Sure. Yeah, I'm here. Yeah, sure.
Okay. Okay, I'm gonna share. Oh, I can't.
Okay, I'll give you whatever powers you need. Try it now.
Okay. Let me just make sure I grab the right one. I remember I closed all my other windows. Okay. So I know this is kind of blurry, but you can sort of see he talks about the symptoms, and he doesn't offer any alternative explanation. And he's quoted verbatim. I don't know, I still don't think that I'm this. And when speaking about, so he talks about speaking about medication and offers of admission. So if you're not going to stay here in involuntary, will you stay here voluntary? Um, I mean, he talks about medication that he did take, but that medication wasn't the only medication. So there was other evidence of and a long period of time. So what kind of treatment and what sort of impact the treatment had. So that's just a tiny example that I was able to find and or to assist, just to help outline. Obviously, there would be some issues if that was just standalone, but it was in the context. There were other, assessments that led to the patient not appreciating the relevant information as it relates to him or her. So those are the things that I just generally outline and look for. Other things that Danielle has outlined above is earlier in terms of where the assessment was done, how long, when it was done, what questions were asked, which information was available at the time, and linking the conclusions that the doctor make back to the diagnosis and back to the treatment and back to the patient. Because oftentimes these doctors are copying and pasting large chunks of information. And if you are familiar with or new to a hospital, I would also watch out for that sort of behavior. Just because it's just rubber stamping the assessment, which is not permitted. I would also pay attention to any Form 47s and any Form 2s. I will give an example as to just generally preparing for cross-examination of the doctor here, just generally, and how beneficial it is to understand the context in which assessments were done for these appreciation tests. One example that I have is in one of the cases that I did, the very first question out the gate was, where did you do the assessment? Where was the assessment conducted? And the doctor couldn't answer because from our position, the doctor didn't really do the assessment. He couldn't tell if he was inside the room, outside the room, the door was open, the door was closed, whether it was through a window, whether it was through a slot, whether the client was sitting on a bed, sitting on the floor. So it was just all these things that would indicate that he couldn't get the assessment done, or he could do the assessment. In that case, the doctor was alleging that the client was violent. To the benefit of the client, he was actually very quiet-natured, but he was a large Indigenous man. So I had a feeling that that may have played into the assessment. So also be cautious to that. And when you're looking at these forms, these Form 47s, the forms too, because if they're bringing themselves to the hospitals, they appreciate the consequences of not taking the medication or the treatment. And if there's no evidence of those forms, you know, that is sort of an objective indicator that they do understand, right? So how do they get there? Is it the police bringing them? Are they calling the ambulance? Are they asking you know, to go with family? And some clients do say, I went in myself. Pay attention to also the context in which the assessments happen. So I don't know how relevant it may be in Southern Ontario, but in more northern rural regions, the risk is that the assessment may be done somewhere that is at like a police station. I had that happen in one case where in one small northern region, the individual was detained on a Form 2, and then he was brought to the police station. At some point, he was assessed there. Not sure how that assessment happened, but then that continued detention happened and then flown down to a hospital where another assessment happened. And so it was like the challenging of, you know, how did the first assessment happen and how that led into the second assessment and appreciation. Again, pay attention to the doctor's observations. So the reliance on external information and whether he is the one observing those observations himself or herself. I'm just looking at my notes. Not sure if anybody has any questions at this time.
I have a question.
Yes.
Good evening. My name is Louis Dallas. Thank you. When your reference to paying attention where the assessment was conducted, and you mentioned in a rural community, it might have been done in a police station. I'm assuming the idea there is a police station is not a very welcoming place. It's a stress-inducing place. So whatever underlying issue the client has, it would be magnified or worsened in that scenario. Is that where you were going with that?
That's part of it, but the other part of it is because the assessments are usually done either a clinical environment or in the client's home, right? So, because sometimes the community treatment team visits their home. So in that particular circumstance, the doctor tried to justify the lack of assessment because the client was violent. But I provide the case law, and it's in that PDF that I refer to. It's KW, the KW case.
Thank you.
And the CCB makes a comment that says, you know, we can appreciate why the client became upset and increasingly upset because it's not clear why he was there. That's a general summary of what was said, but if that is the context of that indicator.
Thank you for clarifying.
And also times like it's the collateral information, right? You often see in these health records collateral information from police who brought the client there, or some sort of charges that the client is facing. And it's like, how relevant is that information, right? Like, did the client come willingly? Did the client have to be arrested? Were there charges? Like,
Thanks.
for the second branch test, one of the questions that always comes to my mind is, whether the client should testify, right? And like Danielle was saying, that is the client's right, and that is the client's way to feel heard. And oftentimes, I just straight up ask the client, do you want to tell your version of events? And sometimes they say yes, and sometimes they say no. Sometimes before the hearing, they say yes, absolutely. And then during the hearing, they're like, oh no, absolutely not. But if they continue to say yes, I frame it as, I tell them, the board will ask you questions, and I sort of ask them questions that I may anticipate from the board so that I can hear how they're going to answer and then give them legal advice as to whether they should testify or not. Oftentimes they'll ask, well, what will you do? What will you say? And I say, I can't do that. This is your right. And I can't tell you what to say. This is you. This is your story. And ultimately your choice to testify. In terms of prepping the client for these for when there's a focus on the subjective part, again, sometimes our clients, I don't want to say are going to lose, but that the decision is not going to be in their favor. So I usually just let them testify. Like, the risk is that, they're going to feel unheard, and the risk is that they're going to get angry, and they're, so there is some benefit to them telling their side of the story, even if the outcome is likely not going to be in their favor. But in terms of how far do I go prepping the client, that's really up to the client. So oftentimes when the client is on a recent CTO, so it's not like the 20th review or the 5th review, if it's usually like the first or second review, I usually take time to really build that prep in with the client, because usually there's a stronger case as to their appreciation of the consequences. Longer term clients also, that may still be available. That doesn't mean that you cannot prep them to that extent. But sadly, there's heavily reliance on that historical narrative for the client. Yes. Question.
Right. Yeah, very often we have to deal with the issue of distinguishing between the ability to appreciate and actual appreciation. I don't know if you can speak a little bit to that. Thank you.
So part of that, hang on, I'm just going to open up my notes. I just want to. So I often ask them, do you like, what's your viewpoint on this? They say, well, I don't have an illness. And say, okay, why are you in the hospital then? Or why have you been on this medication then? And then usually the inquiries flow from there about their ability to appreciate. So it can go one of two ways. Uh, I'm trying to think of a case. There's a case that I did. It was they wanted to put him on a CTO and he didn't want to be on a CTO, and they relied on the ability to appreciate. And uh, I had to prepare him for cross-examination. And those were the questions. I said, do you like why are we here today? Why are you calling me? And he explained to me, I do agree that I have a mental illness, but I just don't agree with the medication. I said, okay. Um, have you thought about different medication? Has the doctor told you about different medication? What was that medication? And you say, okay. And so they sort so that is those are the hallmarks of the appreciation ability to understand, right? Um, I don't know if that answers your question.
I thought that that was a really good question. I find that it's very difficult to explain that to the client, and especially when you have a client that's unwell, you don't want to burden them. They're mainly concerned with, I don't want to take the medication. The capacity is an abstract concept to them, and you've got to really explain to them how the capacity ties into, their power to make the treatment decision. I think what Teo's point is a very good one, because the client often doesn't want the medication, so they disagree, and the doctor in the assessment may say, fails to appreciate the consequences. And so in prepping the client, it is possible to say to the client, if you're going to have them testify, to say, I understand that this time you don't want to take the medication, like today you don't want to take it, but in the future, could there be a time that maybe you would be open to taking the medication? And if you explore that preparation with a client, it may be that you can get them to demonstrate that they do have the ability to appreciate the consequences. And so it's just not a blanket statement. It's very delicate. Anita, do you want to chime in on this issue?
Yeah, I can't help it. Sorry.
Yeah,
This is why I should never be left alone to make the video recording. It's just that I've heard that question a lot over the last 20 years. I first heard it in the Supreme Court of Canada at Starson from, I think, Justice Iacovici, saying, just what is the difference between the ability to appreciate and actual appreciation, if that's the question, right? So I spent a long time thinking about that. What I said at Starson in the Supreme Court 20 years ago was, think about the difference between your ability to drive versus can you drive now? Can you drive? Maybe you cannot. Do you have the ability to drive? You do. You just have to learn. So there are a couple of aspects to it. One, you may well have the ability to do anything, provided you have the information that you need to learn to do whatever it is. So the one reason you may not be able to appreciate the reasonably foreseeable consequences of making or not making a decision is that you haven't been provided the information. So that's something to always look for. But the other part is the difference between the ability to appreciate and then the inability to appreciate versus the failure to appreciate. So we are all entitled to fail to appreciate. There's no such thing as informed refusal, right? So you go into your doctor's office and they want you to take any kind of medication, blood pressure medication, diabetic medication, an antibiotic. You can say to your doctor, no, I'm not gonna. We tend not to do that, but we could. They could say, well, here's what I'd like you to take. And you can say, Yeah, I don't do that kind of stuff. I don't do blood pressure stuff. I don't do cholesterol meds, or I don't do ADHD meds. I don't do stimulants. So we can fail to appreciate by not caring. As capable people, we can say, I don't care. It's just not what I want to do. That's failing to appreciate, because regardless of what the benefit may be or what the risk may be, you simply don't want to do it. So those are some of the differences. I don't know how much more helpful that is, but the ability can be there where the actual appreciation is lacking. Part of the problem with the analysis from the Supreme Court in Starson is that Justice Major, for the majority, starts the capacity assessment backwards. So there is a paragraph in Starson that's often relied upon where the court said any assessment of capacity begins with testing for actual appreciation. The reason that's functionally helpful is if you are testing to see whether someone actually appreciates consequences, then you know they're capable and you don't have to go further to see whether or not they have the ability. But that's not to be conflated with the mistaken notion that you actually have to appreciate anything. And that's where a lot of assessors get confused. They test for actual appreciation, and if it's not there, they deem the person incapable. If the actual appreciation they're looking for is not there, then they have to go to the next step and see, but does the person retain the ability nonetheless to appreciate? And that's what I think you're both getting at, Danielle, in terms of in future,
Yes.
things change. So I think you've all answered the question, but I'm very tired, so I thought I'd wake myself up.
Yeah, thank you. And Anita, I raised the question really because it's something that we really need to look out for in the actual assessment. A lot of times, both the board and the doctor will refer to actual appreciation instead of ability to appreciate. So they're so focused on the actual appreciation that they fail to remember that, look, the test itself is talking about the ability. And I think it's something we have to attune our minds to. Thank you.
Thank you, Teo.
Okay. Where were we? So we're talking about questions. Before I guess we continue, we have some ancillary issues and then the
Sure.
cross-examination.
So I wanted to jump in here, if I may, Naomi, to talk about capacity with respect to property. And, this does come up in applications before the board. And so a lot of this information, actually, I find is not necessarily contained in the progress notes. It's not always the case that the physician will explore these areas. Sometimes you do have a social worker involved who may have probed a little bit about this, but most often I find that the doctor is unaware of this information. So you have to go back to your client. And so what are the things that you're looking for? What are the factors that are relevant for making a determination for capacity with respect to property? So you won't always find this in the file, but you should be asking about what does a client know about income? What does a client know about their rent or their mortgage? Are there any other sources of income or benefits that they receive from the government? Do they hold bank accounts? Do they have debit cards, credit cards, etc.? How much do they spend on recreation? How much do they spend on food? What other financial obligations do they have towards family? Do they know how to pay their bills? Is everything on auto pay? Is it possible to have someone, assist them and set this all up? There's a lot of case law on this. I'm not gonna, we don't have a lot of time, so I'm not going to go into all of the details, but I just wanted to highlight some of the information that you might have to go hunting for, either through your client or through, other avenues, because they're not always contained in the file when you're addressing a Form A application with respect to property. Okay, and I think Naomi, I think that you wanted to also talk about assistive devices.
Yeah, so this I find is coming up more frequently. I find that the findings of incapacity, not just to treatment, but to obviously property and finances is there, but also assistive devices, but also to disclose health information, but to focus on assistive devices, oftentimes, or I'm increasingly seeing more uh, uh, in some of the files that I have, doctors raising that, there's a that they're one example, and I'm not sure this was an assistive device, but um, refusing us assistance in the community, right? So assistance or assisted living in the community, not just living in an assisted housing situation, but social services that would help ensure their success. And another one was serious physical illness and not maintaining the assistive devices to ensure um, uh, that assisted living can happen elsewhere. And so I see this happening more and more where I practice generally, and I haven't really seen it a lot. And maybe it's because there are more older people interacting with the mental health care system. So just that's another thing to watch out for anytime that they say we'll refuse social services. To me, that's a hallmarker of some of those assistive devices, and there has to be an appropriate finding of incapacity relating to that. So you can challenge that in cross-examination.
Okay. I also wanted to raise the issue of the 6-month bar to bringing in further applications. I think that this is something that's very important to discuss with your client. They have to know that if a finding is made, then they're statute barred from bringing another application within the next 6 months, unless there's a material change in circumstances, and that's not an easy test to pass. So you have to really think about this with your client. When is the best time to proceed with a Form A application so that they're successful? Because they will be stuck with that decision for 6 months. The other thing that I think that we are obligated to do as counsel is to raise with them the issue of the appeal. A lot of the clients don't want the medication, and that's their main concern. They really don't care about the abstract notion of capacity and incapacity. And so a lot of them will instruct you to launch an appeal just so that they don't have to take the medication. As you know, it's like a tedious process and it takes a long time. They have to be made aware that the result may be an extended stay in the hospital if the doctor doesn't want to release them and keeps them on a certificate of involuntary admission. But I've had clients who are okay with that, and they're willing to wait it out. And I have had circumstances where I've launched the appeal, and weeks, if not months later, the doctor has let them go, and they haven't received treatment. So that's something to think about. Naomi, did you want to add anything else before we move on to the mock cross-examination that we wanted to do? Because I noticed that it's 7 o'clock, and we wanted to give the participants a demonstration.
Yeah, just briefly, just because where I practice, there's a lot of Indigenous clients. So in Southern Ontario, there may be Indigenous clients, but there may also be other kinds of ethnic backgrounds. So one of the issues in representing Indigenous clients is, particularly where I'm from, is spiritual and cultural practices. So the one decision that I provided was MMB. And that is raised there. So they talk about his delusions and how his delusions are not based in spiritual or religious practices, because in that decision, the doctor had made reference to spiritual cultural practices in her notes, and I asked at the outset, I said, are you going to be relying on these spiritual and cultural practices for your finding of incapacity? She said no. In her notes, obviously that wasn't very clear. And so it's just pay attention for stuff like that. And then always ask the client, you know, to explain the spiritual and cultural practice, or how it connects to them as a person, or how what the doctor is alleging they're doing is a manifestation of a mental illness, and whether they can provide any further explanations. I think that's it.
Okay. So we have a fact situation, and we wanted to give you a little demonstration of a cross-examination of a psychiatrist, and also an examination of the client. So I think we'll start, and I'm going to be the starring role for both of them. So I'm going to be the doctor, and Naomi's going to cross-examine me, and then I will put on an Oscar-worthy performance, hopefully, and become the patient.
Okay. Thank you, doctor, for being here today. How do you say your last name?
Lego.
Lego. Okay, thank you. When was the last time that you met with what's the patient's name again?
Ms. P.
Okay, thank you. When was the last time you met with her?
I met with this client probably this morning, just prior to the hearing.
Okay. And when you say this morning, can you give me an estimate of time? I don't need it to be precise.
Oh, it wasn't long. It was just a few minutes. I just pop into her room to remind her of the hearing, to make sure that she had a tablet and that she knew that we were going to have the hearing today.
Okay. So it sounds like to me that you gave her the tablet right before the hearing, right?
That's right. Well, staff did. I didn't give it to her myself. I just made sure that she knew she was going to get the tablet.
Okay. And it sounds like to me that you didn't do this too long before the hearing, right?
That's right.
Okay. And it sounds like to me that you didn't talk to her about the diagnosis?
No, it was just to say that we're having our hearing today.
Okay, so when I asked you about when was the last time you saw her, you didn't do an assessment at that time?
No, I didn't. There was not enough time.
Okay. When was the last time you did the assessment?
Well, we have an obligation to continually update our assessments. So every time I see my patient, I will always talk to her about her diagnosis and her symptoms. So I always am continually reassessing capacity. But I don't do a formal assessment every single time.
Okay. When you talk about the last assessment that you've done, it's not clear to me when you last did it. Can you please just take a moment to review your notes?
Yeah, so the Form 33 was done on February. I'm going to change the dates from our fax situation, okay? February 17th, 2024. And then in my notes, I see that I did assessments on February 24th and February 21st, as well as the original one on February 17th. So those would be the times that I made written assessments, but there are other times where I would assess her and I wouldn't always make a record that it's an assessment, but I would update the finding of incapacity every time.
Okay. I think that raises an important point for us today. Your finding of incapacity relating to Miss P. I'm just going to go into those questions. Is that okay?
Sure.
Okay. Can you elaborate for me the test for the finding of incapacity, just to make sure we're on the same page?
Sure. I ask questions to make sure that my patient understands the relevant information relating to accepting or declining treatment. So in this case, do you want me to tell you what I did?
I just want to understand what the test is for finding of incapacity, making sure we're on the same page.
So that's branch 1, and branch 2 would be whether or not she has the ability to appreciate the consequences of accepting or refusing treatment.
Okay. And your assessment today of the patient includes what information?
Well, I spoke to the client and I told her that her diagnosis was bipolar. We discussed the fact that she had been in the hospital a number of times presenting with similar symptoms. We discussed her delusions. We discussed her disorganized behavior. We discussed her agitation, and I told her that this was a result of her diagnosis and that her behavior was impacted by her symptoms. And I told her that my proposal was to treat her with antipsychotic medication as well as mood stabilizers. Now, she's refusing all the antipsychotics, but she is accepting the mood stabilizers because she accepts that she has mood swings and that it helps keep that under control. But for the antipsychotics, she doesn't believe that she has this diagnosis, and she doesn't believe that she has any symptoms. She thinks that there's nothing wrong with her. Part of her delusional system is that she believes that she's related to a royal family in Europe, specifically Czechoslovakia. And that's what she believes, and she doesn't accept that that's a symptom of her illness. And so that is why I have found her unable to appreciate the consequences, because she's just refusing to accept that she has any mental disorder at all. She only says that she has a mood disorder that can be controlled by the mood stabilizers. She also has other delusions. For example, she has a dislocated elbow, and she had a prosthesis, but her orthopedic surgeon is now refusing treatment because she says that she's married to him and that he is presently before a secret judicial committee. So when I challenge her on those beliefs, she tells me that it's a secret between her and her orthopedic surgeon, not that it's not true. So she's not willing to accept any alternate explanations of what she sees as true.
Okay. Have you ever talked to her family before?
Her family?
Mhm.
Let me see my notes. I think that I spoke to probably I'm not sure actually. Maybe it was her mother, maybe it was sister, but I have here a note that she was brought to ER by police on a Form 1 because she was threatening to jump off the 3rd floor of a balcony.
Okay.
And those were the circumstances that she was brought into the OR. I mean, ER, sorry.
Okay. So you'd never talked to her family?
Well, I see from the emergency notes that they spoke to a family member who gave information. So I wouldn't have been able to speak to the family member because I wasn't in the emergency room at the time that that was taken, that information was given.
Okay. Do you have any information about Miss P's background, like where she's from?
Well, let me see. No, no, I do not.
Okay. You think it'd be reasonable that she is from Czechoslovakia or Czech Republic, where you indicated earlier?
Well, the problem is that she says that she's the heir to the queen of the future kingdom of Czechoslovakia, and she says that her father is part of the royal family in Czechoslovakia. So she also says that her doctor, her orthopedic surgeon, has been to Europe to meet her family. So based on those statements, I do not believe that she's a member of the royal family in Czechoslovakia. She may have some European ancestry in her, but the European ancestry is not what is concerning to me. What's concerning to me is her delusional belief that she's part of a royal family and that her orthopedic surgeon traveled to Czechoslovakia to meet them.
Okay. What's her orthopedic surgeon's name?
Dr. McKee.
Okay. And do you know him or her?
No, I do not. All I know is that he's not wanting to treat her anymore because of her belief that she's engaged to him.
Okay. So you don't know if he went to Europe?
No, I don't.
Okay.
But I do know that he didn't go to Europe to meet any members of the royal family.
Right.
It's unlikely.
Right. Did you talk to her about the balcony incident?
No, I did not.
Okay. So you didn't ask her why she was on the balcony?
I didn't find it necessary to ask her why she was on the balcony because the police brought her in and reported that she was threatening to jump off the 3rd floor of her balcony. So I didn't think it was necessary to question this.
Do you know how high from the ground the 3rd floor was?
No, I don't, but no, I don't have that information.
Okay. Okay. Is there anything else? Sorry.
Let me see. I just wanted to give a little bit of background information on her about her delusions. She says that she's in hospital for her own protection. She said that there's a contract on her life. She says that she's suing her ex-husband and the government for millions of dollars because the divorce settlement was not adequate, that there was an unfair division of assets. And she also said that there were several people coming to her apartment to threaten her.
Okay.
Yes, and then she also says that part of her family is living in Germany and Italy, and that the Italian branch of her family is flamboyant and crazy. And so she says that I'm misdiagnosing her bipolar because actually it's because she's Italian and she's flamboyant and crazy, and it has nothing to do with a bipolar disorder. And this is in spite of the fact that she's 57 years old. She was diagnosed with bipolar 20 years ago at the age of 37. She's had a number of hospitalizations. She's been a member of the Mississauga ACT community for 6 years. And prior to her recent deterioration, she was relatively stable. And so we would really like to get her back into the community, hopefully on a CTO with the involvement of case managers and under the supervision of an ACT team. But in order to get her there, we have to treat her bipolar, and we want to treat her with antipsychotics in the hospital. And so we can't do that right now because she's brought this application. So we're waiting for this hearing to be over so we can commence treatment.
Okay. So I just want to understand that you'd never talk to any members of any of your family anywhere at any time.
No, I didn't think it was necessary to. I have her medical record saying that, you know, she has a history of a mental illness.
Okay. And she came to the hospital because she was on a balcony, and the police alleged that she was going to jump.
That's right.
Okay. But she didn't jump, right?
She didn't jump because the police intervened. I would hate to think what would happen if the police weren't there.
Okay. But on other times she came for her own protection,
She did say that she came for her own protection.
and she's staying there for her own protection.
That's right, because she says that there's a contract on her life.
Okay. Would you think that these forms are sort of like a contract?
No, I don't think the forms are a contract. The forms are documents which I have served her with under the Mental Health Act because I believe that she needs to be in hospital to remain safe.
Okay. You also allege that she has a court proceeding, right?
Well, I don't know whether it's a court proceeding. She's just alleging that she's suing her ex-husband and the government for millions of dollars because of the divorce settlement.
Okay. So you have no collateral evidence regarding that?
No, I don't.
Okay. I think those are all my questions. Sorry.
Thank you.
I'm just thinking of time and also
Yeah.
like submissions that I'm trying to make. Obviously there are some questions I wouldn't ask, like, is there anything else you want to add?
Yeah, no,
Um,
I think it's important to make the distinction between when Naomi, you were speaking to Danielle, as Naomi and Danielle, like, is there anything else that we haven't covered, as opposed to you would never, like, under pain of death, offer a psychiatrist, particularly Suzanne Legault, is there anything else you wanted to say? That would be like a cross-examination fail. So that was just Naomi asking Danielle, was there anything else? I want to congratulate Danielle on doing like a dead ringer Suzanne Legault. I was getting PTSD listening to the testimony. Well, no, I didn't think that would be necessary. Did you want me to go on? It was very effective, but it's time now to switch to the Danielle patient because we are to end at 7:30, and if there's one thing I'm ruthless about is we will end at 7:30. So if you want to do a sort of truncated version of the evidence and cross of the patient, and then if people do have questions, I will look in the chat for them. But you can also, hopefully there'll be a few more minutes at the end for those questions. Well done.
okay.
Oh, I should say one more thing. So the reason Danielle was Suzanne Legault is not just because we want to pick on her, although I think many of us would be happy to, but it's mainly because she is the doctor in this case. So they were keeping true to, I think, the facts there. I also feel very sorry for that doctor, the orthopedic surgeon, whose real name is in this case, and this fact pattern is frequently used to teach some of these issues. So I think his name's out there more for the allegation of the affair that he's had with his patient than the good work, no doubt, he does as an orthopedic surgeon. Okay, keep going. We're almost done.
Okay. Thanks, Ms. P, for being here today. So I'm just going to ask you some questions, okay?
Yes.
Okay. Can you tell me a little bit about yourself?
So I'm 57 years old and I live on my own. I receive benefits from the government, and so I'm financially independent.
Okay. In terms of your reasons for coming to the hospital, can you explain a bit about that?
I don't know what happened or why someone called the police. I don't know. All I know is I stepped out on the balcony because I wanted some fresh air. And before I knew it, people were accusing me of trying to jump off. I was not going to jump off the balcony. I just wanted to step out from fresh air. And before I knew it, the police came and they lunged at me. They put handcuffs on me. They knocked me to the ground. I have scratches all over my body and my knees because of this. They treated me roughly, and I was not aggressive at all. There was no reason for them to handcuff me at all. They didn't even ask me any questions. They just knocked me to the ground and handcuffed me and took me to the hospital. I'm very traumatized by it. They injected me at the hospital. They held me down. They strapped me down to a gurney. I didn't even know what was happening. I was so upset. It was very upsetting what happened.
Okay. Thank you for sharing that. I'm sorry that happened to you. Can you explain to the board a little bit about your background?
Sure. I've lived in Canada all my life. I'm Canadian, but I have relatives who are European, and I have traveled to Europe several times. And I tried explaining this to the doctor, but every time I talk about this, people think that I'm crazy.
In terms of some of your past hospitalizations, did you want to provide some information to the board?
Yes, I have been diagnosed with bipolar at the age of 37. I'm 57 now, and I've had a number of hospitalizations. So I know what it means to be medicated, and I don't like it. And I was working with an ACT team for 6 years in Mississauga, and they were very good. They would come and see me, and they would make sure that I would take my mood stabilizers. And I find that I'm okay as long as I have my mood stabilizers. But I don't like the antipsychotics. They make me feel dizzy and numb. And I just think that they're over medicating me, and it makes me very sleepy. And if it doesn't make me sleepy, it makes me shaky during the day. I just don't like the way that I feel, and I don't know why I have to have like all these different medications. I'm okay with the mood stabilizer, and I am taking it. And that's all that I want to take, and it should be my choice. I've lived with this illness for a long time. I know it's an illness, and yeah, I don't want to take the antipsychotic. And the doctor is forcing me to take it.
Okay. So I hear you say that you know it's an illness and you have this illness. Is that what I heard?
I do, but I don't like the way that the doctor's describing some of my thoughts as delusions. It's like whatever I say, they say it's a delusion because I'm psychotic. That's not true.
Okay. Can you give us an example of what you don't agree with?
Well, they're saying things about Dr. McKee, and it's very private what happened between Dr. McKee and me, and I don't feel comfortable talking about it here.
Okay, I understand. Um, in terms of your what I heard you say was that you um you don't want to take the medication. Is that what I heard?
I don't want to take the antipsychotics, but I am taking the mood stabilizers.
Okay. Can you describe the conversations about the treatment options that you had with the doctor for bipolar?
Yeah, they told me that they thought that I had this mental condition that required that required the antipsychotic. They told me that I'm bipolar. I have no choice. I'm always going to be on it. They're going to put me on a CTO, and no matter what happens, I'm going to be on this medication.
Okay. So did they give you an option to take other medications?
Nope, they just told me that they would force me to do it, and they would keep me in the hospital for as long as it took. And I would just stay here and rot until I take the medication.
Okay. Did they explain to you what if you said no?
They told me that they would get security and inject me and force me to take it.
Okay. I'm gonna stop right there. Just because it's 7:24 and I don't know if people want to ask questions. So I can explain a little bit about sort of some of the stuff that I was probing at. Did you talk to the family, right? So in this kind of circumstance, if I was reading health record notes, I would ask the client, what's your background? Where are you from? Sort of to explain away those delusions. Um, uh, and then sort of to ask her to explain like what is the royal family situation? What's that? What is that there? Um, and then I asked about the balcony incident because 3 floors sometimes isn't that high. It could be the second floor, and the basement could be the first floor. And there could be number 2, which is the ground floor, and then the second floor. And it could be just a way to get down. It could be a tiny apartment, it could be a tiny building. Um, it could be that she sits out there and sometimes she does jump down. Like who knows? But those are things that I would probe the client with prior. And then sort of who are her neighbors like, what are the relationships with the neighbors? And oftentimes these clients are living in housing, social housing, so the neighbors are not always that great. And you know, there is a possibility that somebody had a delusion about her jumping, right? So I would just probe that with the client if this sort of thing came up. And that's why I was sort of asking questions around that.
No, and I think that that's exactly right, Naomi. I think that the way that you systematically were trying to, pick apart the delusions one by one, and to just say, look, there may be an alternate explanation for the client's beliefs that is not a delusion, or maybe there's some morsel of information in there that is true and accurate and reasonable, but it's been distorted by the surrounding parties. And so by the time she gets to the hospital, it gets presented as a delusion. I think that that's the best that we can do as counsel, is to, shine a light on the delusions and say, look, maybe not all of this is a delusion. Maybe there's a reasonable explanation for it.
Yeah, and if the doctor hasn't talked to the family and is relying on that for delusions, it's probably a good reason for the doctor to talk to the family.
That's exactly right.
Well, and the other thing about treatment of bipolarity, right, is mood stabilizers, if given long enough and stabilize the mood, may well have that antipsychotic impact at the end of the day, right? So client's not necessarily wrong to say, I don't want the antipsychotics. If you develop psychosis when you're manic, if you get the mania under control, those delusions may also resolve, right? They want to give you antipsychotics because they want a quick resolution to what they see are your psychotic symptoms, but that you may not need them. So there's all of that to it. Plus, if your surgeon is having an affair with you as their patient, they would want to keep that secret, right? So if she's going around saying it's a secret and he's saying it didn't happen, those are also consistent with, who knows? There's lots of doctors sleeping with their patients. There's lots of husbands, in big litigation over assets with their wives. Maybe she got a DNA test on the internet that told her she's the next heir of the future kingdom of Czechoslovakia. Who knows, right? You probe these allegations of what is delusional, because most of our clients' delusions will have a basis in reality. Somehow there will be something somewhere that you can exploit and explore, like Naomi did here. Also, you can't die jumping from a lower floor than 4. That's why psych units, seriously, I actually read that as a fact. That's why psych wards tend to be on 4 or lower. They tend not to be particularly high up. If you notice that about hospitals. I think the actual fact scenario, if you read it carefully, from what I recall, has her threatening to jump off a first floor balcony. So it's actually even more ridiculous, like a patio level balcony. Anyway, we are at 7:29. I don't see any questions, which just means that our wonderful guests, Danielle and Naomi, have been so clear and so compelling that everybody now knows exactly what to do and how to do it, particularly when they get this particular fact scenario in front of them. Great job, you guys. I want to take a picture. So first, let's just take a group photo. Naomi and Danielle. Perfect. And everyone who can please turn your cameras on, everyone who's able. It's not mandatory, but we'd be happy to have a
Some
group.
of us are stopped from turning on our camera. You kindly turn me on, please.
Oh,
Linus Ali.
oh, you're 100% right. I did that to you at the beginning when I was trying to figure out. Sorry. Oh no, there you are. No, did you get your camera back then?
No, not yet.
Okay, then I on top of that, I've lost you. This isn't very good. Hang on one second. You're not on my screen. One sec.
Why is my camera not showing? Yeah.
Oh, because you're hidden. So you want to turn your camera on.
Yeah, my camera's on. That's weird.
My camera is not on, but I mean it's on. It's not on because it was turned up from there. Turned off
Yes.
from there.
I turned it off. Yes.
Okay.
So you just have to tell me where I find you on my screen. So just give me your name where I find you.
Linus L Ali.
Ah, there you are. Okay, let's see. Ask
Okay.
to start video. There you go. Now you just have to answer me that it's okay to start your video.
Same thing, Anita. My camera was on before, but now I can't seem to. It's
Kyle?
on? Yeah.
Thank you.
No, that's you. I haven't done that
That's
to you.
me?
I only
Oh.
did it to the one poor gent. So you just have to turn that on yourself. I can't help you. Mine says, for me, it says it's on. Esther, you have a question? This picture taking is not going as smoothly as it normally does. Okay, I'm going to take the picture anyway. Everybody say 1, 2, 3, Suzanne Legault. Suzanne Legault. Perfect. I actually have so many people I have to switch screens. 1 second. Oh, this is, as everybody knows, this is my favorite part where I say, you have to smile now for the camera, and everyone does, even though most people are not on this screen. It's because nobody has any idea what screen they're on. Okay, so apologies to those who were inadvertently silenced, muted. Esther Abraham, you have your hand up. I don't know if you want to, but last time I asked you this, you started to talk, you were muted. So I don't know. Here.
I don't have any question. Thank you. That might be.
I'm glad we went through that then. Okay, everyone. Thank you for coming. This is a very informative session. This was part 2, and we are returning in March, I think, March 14th, something like that. Part 3, I believe, on involuntary admissions. You have the list. You have prize-winning materials that nobody else will get, and you should really enjoy them a lot. Poor Teo, she's dropped off and she's coming back. I'll wait for her to come back. Anyway.
Anita, I had one really quick question. I'm sorry. The correct spelling of that case, Starsen, S-T-A-R-S-E-N, is that right?
It's close. It's S-O-N. He made it up himself. His real name is Schutzman, Jeffrey Schutzman. Scott Schutzman, Scott Jeffrey Schutzman. And he decided that he was a son of the stars. So he called himself Star Son.
Wow. Okay.
I mean, who can blame him? Who wants to be known as Schutzman? So much better.
Thank you.
Oh, I probably should have stopped the recording earlier. Too late now.